On November 12, 1847, in the probate of Charleston, South Carolina, an enslaved man named Isaac stood in the back of the courtroom during the reading of his master's will. Colonel Richard Hartwell had died 3 weeks earlier at age 62, leaving an estate valued at $47,000, including land, securities, and 53 enslaved people. The will's fourth provision identified Isaac's age as Colonel Hartwell's biological son by an enslaved woman named Rebecca, acknowledged his paternity, and transferred ownership of Isaac to Hartwell's legitimate white son, William, along with the rest of the enslaved property. Within 2 months, Isaac would file a freedom petition in Charleston court arguing that his father's written acknowledgement of paternity his enslaved status. William Hartwell would countersue to have Isaac sold out of state for insubordination, and the case would expose how South Carolina law permitted white men to own children while simultaneously creating legal mechanisms to acknowledge that ownership. How does a son respond when he learns his father's final act was to confirm both his existence and his bondage in the same sentence? Subscribe to the Bondage Chronicles for stories that document the legal architecture of American slavery. Let's return to where it began. Isaac carried the colonel's trunk down from the second-floor bedroom where Richard Hartwell had died, moving carefully on the narrow stairs to avoid scratching the walnut paneling. The trunk was leather-bound with brass fixtures and weighed approximately 80 pounds when full. It contained the colonel's personal papers, account books, and correspondence that William had requested be brought to the library for review before the will reading. Isaac had performed this kind of task hundreds of times during the 28 years he had lived on the Hartwell estate, first as a child running errands, later as the colonel's personal servant, responsible for his wardrobe, his travel arrangements, and the maintenance of his private quarters. The colonel had never explained why Isaac received these assignments instead of being sent to work in the fields or the rice mills that generated the estate's wealth. Isaac had learned not to ask questions about assignments. Questions invited attention. Attention invited trouble. William Hartwell waited in the library, standing by the window with his back to the door. He was 44 years old, 6 years older than Isaac, and had managed the estate's business operations for the past decade while the colonel's health declined. He did not turn around when Isaac entered. He told Isaac to place the trunk on the desk and open it. Isaac did so, using the key William handed him. The trunk's interior was organized with the precision the colonel had demanded in all aspects of his household. Documents by type and date, tied with string, labeled in the colonel's small, careful handwriting. William approached the desk and began removing bundles, examining labels, setting aside those that appeared relevant to estate settlement. Told Isaac to wait by the door in case additional items needed to be retrieved. Isaac stood with his hands clasped behind his back, eyes forward, adopting the pensive readiness that enslaved house servants learned to maintain during indefinite waiting periods. William found what he was looking for after 10 minutes of searching. He pulled a sealed envelope from the bottom of the trunk, examined the wax seal, and placed it in his jacket pocket without opening it. He told Isaac the trunk could be returned upstairs. Isaac moved to close the lid. William stopped him and said the colonel's watch was missing from the trunk, that it should have been there. Isaac needed to locate it before the will reading in 3 days. Isaac said he would search the bedroom. William said the watch was gold, Swiss-made, extremely valuable, and that if it was not found, there would be consequences. Isaac said, "Yes, sir." William dismissed him. Isaac carried the trunk back upstairs, returned it to the bedroom, and began searching for a watch he had never seen the colonel wear and suspected did not exist in the location William claimed it should be. The search occupied the next 2 days. Isaac went through every drawer, cabinet, and storage space in the colonel's bedroom and study. He found account books documenting crop yields and sales going back 30 years. He found correspondence with Charleston merchants, rice factors, and slave traders. He found a locked wooden box containing daguerreotypes of the colonel's deceased wife and their 3 children at various ages. He found no watch. On the second day of searching, he asked Sarah, the cook who had worked in the Hartwell house longer than anyone else, if she remembered the colonel owning a gold Swiss watch. Sarah looked at him carefully before answering. She said she had never seen such a watch. She asked why William wanted it found. Isaac said William had not explained, only that consequences would follow if it remained missing. Sarah told Isaac to be careful, that William had been asking questions about the will's contents, that the colonel's lawyer had been in the house twice since the death, and that William's questions and the lawyer's visits suggested complications in the estate settlement. Isaac asked what kind of complications. Sarah said she did not know, but that Isaac should stay quiet, work carefully, and avoid giving William any reason to focus attention on him. Isaac asked why William would focus on him. Sarah did not answer, which was answer enough. The will reading was scheduled for November 12th at 10 in the morning in the Charleston Probate Court. William informed the household's enslaved people that them would need to attend, because the will contained specific bequests and required their presence for documentation purposes. Isaac was among those required to attend. This was unusual. Enslaved people typically learned about ownership transfers through their new masters, not through direct attendance at legal proceedings. Isaac asked William why his presence was required. William said the lawyer had requested it, and that Isaac should dress appropriately and arrive at the courthouse by 9:30. Isaac owned 2 sets of clothing, work clothes and the slightly better clothes he wore when serving the colonel at formal dinners or accompanying him on trips to Charleston. He wore the better clothes. He walked the 3 miles from the estate to the courthouse, arriving at 9:15 to allow time for any unexpected delays. The courthouse was a 2-story brick building on Meeting Street that handled probate, civil disputes, and minor criminal cases for Charleston County. Isaac entered through the side door that enslaved people were required to use and found the room where the reading would take place. It was a standard courtroom with wooden benches, a judge's platform, and a clerk's desk. Approximately 20 people were already present. William Hartwell and his 2 sisters, the colonel's lawyer, several white men. Isaac did not recognize who appeared to be creditors or business associates, and 6 enslaved people from the Hartwell estate, including Sarah. The enslaved people sat in the back row. Isaac joined them. William glanced at him, but said nothing. The lawyer, a man named Preston who had handled the colonel's legal affairs for 2 decades, arranged papers on the clerk's desk and spoke quietly with the judge, who had entered from his chambers. The reading began at 10 o'clock precisely. Judge Morrison, a gray-haired man in his 50s, instructed everyone to remain seated and silent unless called upon to speak. He explained that the will would be read in its entirety, that questions would be addressed afterward, and that the court's role was to ensure execution of the deceased's wishes according to South Carolina law. Preston stood and began reading from a document that ran to pages of dense legal text. The first 3 pages dealt with debts, funeral expenses, and minor bequests of personal items to friends and associates. The 4th page addressed the distribution of real property. The estate's main hounds to William, 2 smaller properties in Charleston to the colonel's daughters, various finance instruments divided among the 3 children according to specific percentages. Preston read aloud with careful precision. The 5th page began the section on enslaved property. Preston read slowly, naming each enslaved person and their assigned new owner. Most went to William as the primary heir. A few skilled workers went to the daughters. Some elderly enslaved people were designated to remain on the estate for life with provisions for their care. Preston reached the section labeled Spatial Provisions and paused briefly before continuing. He read, "I acknowledge that Isaac, male, age 28, currently serving as my personal attendant, is my natural son by Rebecca, deceased, formerly my property. I acknowledge this paternity freely and without coercion. I transfer ownership of Isaac to my son William Hartwell, along with all other enslaved property not otherwise designated in this document." Preston stopped reading and looked at the judge. The courtroom was completely silent. Isaac sat motionless in the back row, his face showing no expression, hands folded in his lap, his mind, through what had just been stated in formal legal lay language, in front of witnesses whose presence made the statement a permanent part of public record. William Hartwell stood up. He asked the judge if the provision was legally binding. Judge Morrison said that acknowledgement of paternity did not alter the legal status of enslaved individuals under South Carolina law, that Isaac remained property of biological relationship, and that the transfer of ownership to William was valid and enforceable. William asked if there were any restrictions on his ownership rights. The judge said no, that ownership was complete and unrestricted. William sat down. Preston continued reading. The remaining 3 pages dealt with executor provisions, trustee appointments, and various administrative details. When Preston finished, Judge Morrison asked if anyone present had questions or objections. No one spoke. The judge declared the will probate invalid, instructed Preston to file the necessary documentation, and dismissed the court. The entire proceeding had taken 43 minutes. Isaac remained seated while others left the courtroom. Sarah touched his arm gently but said nothing. The other enslaved people filed out through the side door. Isaac stood slowly and followed them. Outside, William was speaking with Preston on the courthouse steps. They saw Isaac emerge and stopped talking. William called Isaac over. Isaac approached and stood at the appropriate distance, slightly below them on the steps, eyes down, posture indicating subordination and availability for instructions. William told Isaac to return to the estate and resume his normal duties. Isaac said, "Yes, sir." William told Isaac they would discuss his future assignment after the estate settlement was complete. Isaac said, "Yes, sir." William dismissed him. Isaac walked back toward the estate alone, maintaining steady pace, showing no urgency or distress, performing the role of obedient property even as his mind processed the reality that his father had owned him legally, acknowledged him biologically, and transferred him to his half-brother as inheritance, all in coherent legal transaction that the court had validated without hesitation or concern. 2 weeks after the will reading, a man named Harris appeared at the estate asking to speak with Isaac. Harris was a free black man from Charleston who worked as a clerk for a white lawyer who occasionally handled freedom petitions for enslaved people with unusual legal claims. Harris told Isaac that he had been present at the will reading as an observer, that he had noted the paternity acknowledgement, and that South Carolina law contained a rarely used provision allowing enslaved people to petition for freedom in cases where their enslavement contradicted other established legal principles. Harris said Isaac's case might qualify because the will created a legal paradox. The colonel had affirmed Isaac's status as his son while simultaneously affirming his status as property transferable to another son, and South Carolina's law presumed that legitimate children from fathers. But this will explicitly stated Isaac was the child while denying him any inheritance rights. Harris said the provision was obscure, the precedent was limited, and the likelihood of success was small, but the petition was legally available if Isaac chose to file it. Harris left a paper with the lawyer's name and office address. He told Isaac the decision was his alone and that if he chose to file, he should understand the risks. William could interpret the petition as insubordination and respond with punishment or sale, The court could deny the petition and reinforce Isaac's status more strongly than before, and other enslaved people on the estate could face consequences if William to make an example of the situation. The paper remained hidden in Isaac's cabin for 3 days. He told no one about Harris's visit. He continued his assigned duties, serving William with the same efficiency he had shown the colonel, demonstrating no change in behavior or attitude. But the information Harris had provided changed how Isaac understood his situation. Before the will reading, he had suspected the colonel might be his father based on resemblance. Sarah and others had sometimes mentioned quietly, based on his assignment to housework instead of field labor, based on small privileges like learning to read that the colonel had permitted without explanation. The will had transformed suspicion into documented fact. But it had done something else. It had made Isaac's enslavement legally explicit in a new way, tying it directly to acknowledged paternity, creating written evidence that his father had chosen to keep him enslaved despite biological connection and despite having legal authority to free him. Harris had suggested that this explicitness created legal vulnerability. If the colonel had simply transferred Isaac without comment, the transaction would have been routine. By acknowledging paternity in writing, the colonel had potentially created grounds for challenging the transfer under inheritance law that presumed children inherited from fathers. The argument was technical and uncertain, but it existed. Isaac had to decide whether filing a petition based on this argument served any purpose beyond establishing a legal record of protest, and whether that record justified the risks Harris had outlined. The decision required calculating odds Isaac had no reliable way to calculate, and accepting consequences he could not fully predict. On the 4th day, Isaac walked to Charleston and found the lawyer's office. The lawyer, a man named Caldwell who had defended several freedom petitions in the past decade, listened to Isaac's summary of the will's provisions and Harris's interpretation of the legal issue. Caldwell said Harris was correct that the provision created potential grounds for a petition, that South Carolina courts had consistently ruled against freedom claims by enslaved people except in cases written promises of manumission that owners had failed to execute. Acknowledging paternity was not equivalent to promising freedom. The colonel's will explicitly transferred Isaac to William, which demonstrated clear intent to maintain Isaac's enslaved status. Caldwell said he could file the petition if Isaac wanted to proceed, but that Isaac should expect it to fail and should prepare for William's response. Isaac asked what form that response might take. Caldwell said William could do nothing and let the legal process resolve itself, or William could act preemptively to demonstrate his own authority and discourage future challenges. The second option usually meant punishment or sale. Isaac asked how long the legal process would take. Caldwell said 6 to 8 weeks for initial hearing, longer if appeals were involved. Isaac said he would consider the decision and return with an answer. The choice presented itself in binary terms: accept permanent enslavement under William's ownership without legal challenge, or file a petition that would almost certainly fail but would create a documentary record that Isaac contested his status based on his father's written acknowledgement of their relationship. The first option guaranteed continued servitude, but avoided immediate retaliation. The second option had retaliation, but established that Isaac had claimed legal standing as the colonel's son, even if that claim was denied. Isaac understood that the petition's real purpose was not winning freedom, but forcing the court to state explicitly whether being a white man's acknowledged son provided any legal protection from being that man's property. The answer was almost certainly no, but making the court so officially had value Isaac could not precisely define but felt nonetheless. He returned to Caldwell's office 2 days later and instructed him to file the petition. Caldwell prepared the document that afternoon. The petition stated Isaac's name age, and current owner. It summarized the will's paternity acknowledgement. It argued that South Carolina inheritance law presumed children inherited from fathers, and that treating an acknowledged son as transferable property contradicted that presumption. It requested the court grant Isaac's freedom based on this legal inconsistency. Caldwell filed the petition with the Charleston Probate Court on November 28. The court scheduled a hearing for January 15, 48 days away. William Hartwell was notified of the petition on November 30. His response came the next morning. William arrived at Isaac's cabin at dawn with the estate's overseer, a man named Drummond who handled discipline and labor management for field workers. William told Isaac to come outside. Isaac complied immediately. William asked if Isaac had filed a legal petition challenging his ownership. Isaac said yes. William asked on what grounds. The petition argued that the colonel's acknowledgement of paternity created legal complications regarding inheritance. William said there were no complications, that the will was clear, that Isaac was property, and that filing the petition constituted insubordination that required correction. He told Drummond to administer 20 lashes. Drummond said Isaac to remove his shirt. Isaac removed his shirt. Drummond administered the punishment in the yard outside the quarters, where other enslaved people were beginning their morning routines. The whipping was procedural, not excessive by plantation standards, calibrated to demonstrate authority without causing injury that would reduce Isaac's work capacity. When it finished, William told Isaac to report to the main house at 8 o'clock. Isaac said yes, sir. William and Drummond left. Sarah brought water and cloth to clean Isaac's back. She did not ask why this had happened, because the other enslaved people had already heard about the petition and understood the punishments. Isaac reported to the main house as instructed. William was in the library reviewing correspondence. He told Isaac that the petition was an embarrassment to the family and an insult to the colonel's memory. He said he had consulted with Preston, the estate's lawyer, about options for responding. Preston had advised that the petition would almost certainly be denied by the court, but that allowing it to proceed created publicity that reflected poorly on the Hartwell name. Preston had suggested an alternative. William could sell Isaac to a buyer outside South Carolina before the hearing date, which would moot the petition because Isaac would no longer be William's property and would have no standing to challenge ownership by someone else. William said he had accepted this suggestion and had already contacted a slave trader in Charleston who purchased enslaved people for resale in Louisiana. The trader would arrive in 3 days to examine Isaac and negotiate price. Once the sale was complete, the petition would be withdrawn and the matter would be resolved. William told Isaac to prepare for departure. Isaac asked if the sale could be delayed until after the court hearing. William said no. Isaac said he understood. William dismissed him. The next 3 days proceeded with mechanical inevitability. Isaac continued working in the main house, while William finalized arrangements with the trader. Sarah and the other enslaved people avoided discussing the pending sale directly, but their behavior communicated their awareness. Small gestures of extra food, quiet company in the evenings, careful avoidance of topics that might cause Isaac additional distress. On the 3rd day, the trader arrived. His name was Bennett, and he operated a business that purchased enslaved people in Virginia and South Carolina for transport, deep South markets where labor demand and prices were higher. He examined Isaac with professional efficiency, checking teeth, muscle development, scars, and overall health. He asked William about Isaac's skills and work history. William said Isaac had served as personal attendant, could read and write, had no history of running away or violent behavior, and was being sold due to family estate reorganization. Bennett asked if there were any disciplinary issues. William hesitated briefly before saying Isaac had shown signs of insubordination but nothing that affected his work quality. Bennett offered $800. William $1,000. They settled on $900. Bennett paid in cash and banknotes. William provided a bill of sale. The entire transaction took 20 minutes. Bennett told Isaac to gather his belongings. Isaac owned almost nothing. Changes of clothes, a knife, a tin cup, a blanket. He collected these items and returned to where Bennett waited with a wagon and 5 other enslaved people Bennett had purchased from estates in the area. Bennett told Isaac to get in the wagon. Isaac climbed in and sat on the wagon bed. Sarah appeared from the kitchen and handed Isaac a cloth bundle containing food for the journey. She looked at his face but said nothing. Isaac took the bundle. Bennett drove the wagon down the estate's main road toward Charleston. Isaac watched the Hartwell house recede into the distance. He had lived there for all 28 years of his life. He would never return. The petition remained filed with the probate court, scheduled for hearing in 41 days, but Isaac would not present to pursue it because he would be in Louisiana by then, owned by whoever Bennett sold him to, with no legal standing to claim anything about his father or his past. The journey to New Orleans took 4 weeks. Bennett transported enslaved people by wagon to the South Carolina coast, by ship to Mobile, and by river boat up to New Orleans. The conditions were standard for slave transport. Minimal food, crowded quarters, no medical care for illness or injury. 2 people in Bennett's group became seriously ill during the voyage. Bennett isolated them to prevent contagion, but provided no treatment beyond basic provisions of water. 1 recovered. The other died 3 days before reaching New Orleans. Bennett disposed of the body at the next port stop and adjusted his inventory records accordingly. Remained healthy throughout the journey. He spoke little to the others being transported. He spent most of the journey thinking about the petition, about whether appear at the January hearing to explain Isaac's absence, about whether the court would dismiss the case for lack of standing or rule on the legal claim regardless, about whether William would inform the court that had been sold, about whether any record of the petition would survive in legal archives where it might possibly be discovered by someone who would understand its significance. Bennett sold Isaac in New Orleans within 2 days of arrival. The buyer was a plantation owner named Rousseau, who operated a sugar estate 50 miles upriver and needed experienced house servants. Rousseau paid Bennett $1,200, $300 more than Bennett had paid William, representing Bennett's profit margin on the transaction. Rousseau asked Isaac about his previous work experience. Isaac described his duties at the Hartwell estate, managing the colonel's wardrobe and correspondence, maintaining household schedules, overseeing other house servants, handling interactions with visitors. Rousseau asked if Isaac could read and write. Isaac said yes. Rousseau seemed pleased. He told Isaac he would work as head house servant at the Louisiana estate, reporting directly to Rousseau's wife, with responsibility for coordinating all domestic staff. The work would be similar to what Isaac had done in South Carolina. Isaac said yes, sir. Rousseau asked if Isaac had family in South Carolina. Isaac said his mother had died years ago and he had no other family. This was technically true. His father had died in October. His white half-siblings did not constitute family in any meaningful sense. Rousseau said that was good, that enslaved people without family ties adjusted better to new situations. Isaac said nothing. The January 15th hearing, without Isaac present, Caldwell appeared in Charleston probate court and explained to Judge Morrison that petitioner had been sold and transported to Louisiana, that his current whereabouts were unknown, and that his absence made it impossible to pursue the petition. William Hartwell's lawyer, Preston, argued that the sale demonstrated the petition had been filed in bad faith as a delaying tactic, and that it should be dismissed with prejudice. Caldwell responded that the sale had been conducted specifically to prevent the hearing, that this amounted to interference with legal process, and that the court should rule on the underlying legal question regardless of the petitioner's location. Judge Morrison took 10 minutes to consider both arguments. He ruled that, without the petitioner present, the court lacked jurisdiction to grant the requested relief, and that the petition was therefore dismissed. He did not address the legal question of whether acknowledging paternity created any inheritance rights. He did not criticize William for selling Isaac before the hearing. He did not note the timing as suspicious or problematic. He simply closed the case and moved to the next item on the court's calendar. Caldwell wrote a letter to Isaac care of Bennett's New Orleans office describing the hearing's outcome. Bennett received the letter but did not forward it because he no longer had contact information for buyers after sales were completed. The letter remained in Bennett's files until his business closed 3 years later, at which point all records were discarded. Isaac never learned what happened at the hearing. He worked at Rousseau's estate for the next 6 years, performing the duties of head house servant with the same competence he had shown at the Hartwell estate. He learned French to communicate more effectively with Rousseau's Creole relatives who visited frequently. He managed a staff of other house servants. He handled Rousseau's correspondence when Rousseau traveled on business. In 1853, Rousseau died unexpectedly of yellow fever. His estate was sold to settle debts. Isaac was purchased by a cotton factor in New Orleans who needed a clerk for his warehouse operation. Isaac worked as warehouse clerk until 1861, when the Civil War began and disrupted commercial operations throughout the South. In April 1862, Union forces captured New Orleans. The cotton factor fled the city, abandoning the warehouse and the enslaved people who worked there. Isaac remained in the warehouse building with several others. Uncertain about their legal status and unsure where to go, Union officers arrived 2 days later and informed them they were contraband of war, effectively free but not yet legally emancipated, entitled to remain in Union-controlled territory and seek employment. Isaac asked if there was any process for documenting previous legal claims to freedom. The officer said the Union Army was not adjudicating pre-war Southern court cases, and that everyone in Union territory was considered free regardless of their previous legal status. Isaac did not pursue the question further. He found work as a clerk for a Union Army quartermaster, handling supply records and requisition forms. He performed this work for the remainder of the war. After the war ended, Isaac remained in New Orleans. He worked various clerical jobs, saved money, and eventually purchased a small house in a neighborhood where free black people and formerly enslaved people were establishing a community. He married a woman named Grace, who had been enslaved on a plantation in Mississippi and had made her way to New Orleans during the war. They had 3 children. Isaac told Grace about the Hull estate, about the will reading, about the petition, about the sale that had prevented the hearing. Grace asked if he wanted to return to South Carolina to search court records or pursue the legal question. Isaac said no, that the war had resolved the legal question more definitively than any court ruling could have, and that spending time and money on documentation of what had happened 847 served no practical purpose. Grace accepted this but asked if the story should be preserved for their children. Isaac said yes, the children should know what had happened, not as a source of anger or resentment, but as historical fact about how the system had operated. Isaac lived in New Orleans until 1889, working as a clerk and bookkeeper for various businesses, raising his children, and participating in the city's black community organizations. He never returned to South Carolina. He never contacted William Hartwell or attempted to any portion of the Hartwell estate. He never saw the petition document again or happened to court records from the hearing. In 1887, 2 years before his death, he dictated a written account of the will reading and petition to his oldest son, who had learned to write well and worked as a schoolteacher. The account ran to 4 pages and described the events in chronological order without emotional commentary. Isaac's son kept the document. It passed to Isaac's grandchildren. One grandchild donated it to a Louisiana Historical Society in 1932 as part of a collection of family papers documenting formerly enslaved people's experiences. The Hartwell estate remained in the family until 1901, when William's children sold it to a Charleston development company. The house was demolished. The land was subdivided for residential construction. The estate's records, including the colonel's will and plantation ledgers, were transferred to the South Carolina Historical Society. The will is accessible to researchers who request probate records from Charleston County for 1847. The 4th provision, acknowledging Isaac as the colonel's son and transferring his ownership to William, remains visible in the original document. No annotation or explanation accompanies it. It exists as a standard clause in a standard estate distribution, notable only for its explicit statement of what was normally left implicit, that men could acknowledge biological children and transfer ownership of those same children in the same legal instrument, with no contradictionized by law or custom. The petition Isaac filed was not preserved in accessible archives. Charleston probate court records from the period are incomplete, with many documents lost or discarded during Reconstruction and subsequent decades of record management changes. Searches conducted by historians in the 1960s and 1980s found references to freedom petitions filed in the 1840s, but could not local documents. Caldwell's law office closed in 1855 when Cald died. His files were dispersed among other lawyers or discarded. No known copies of the petition exist. The only documentation that it occurred comes from Isaac's 1887 written account, which mentions filing a petition in November 1847 and describes Caldwell preparing the document. Historians consider the account reliable based on its consistency with known legal practices and its specific details about dates and procedures, but no independent verification is available. William Hartwell died at 876, leaving an estate valued at $62,000 to his 4 children. His will contained no unusual provisions. None of the enslaved people had appeared in the document by name. They had all been freed by the 13th Amendment in 1865, making specific bequests unnecessary. William's obituary in the Charleston newspaper described him as a respected businessman and community leader who had managed the family estate with skill and maintained the Hartwell reputation through difficult political and economic times. The obituary made no mention of the 1847 will reading or the freedom petition. These events were not considered relevant to public assessment of William's character or legacy. The South Carolina inheritance law that Isaac's petition relied on remained unchanged through the Civil War and Reconstruction. The statute presumed that children inherited from fathers and outlined procedures for distributing estates among legitimate heirs. It contained no provision addressing enslaved children's inheritance rights because enslaved people were property, not heirs, and the law recognized no contradiction between biological paternity and property ownership. The statute was amended in 1868 to remove language specific to enslaved property, but the core inheritance framework remained identical. Courts applying the revised statute in the 1870s and 1880s ruled that children had no retroactive claim to if fathers had distributed before emancipation, establishing precedent that biological relationship created no inheritable rights unless rights had been legally recognized at the time of the father's death, which cases involving enslaved children they never were.